Intrafamily violence is defined as any criminal offense that would be listed under the criminal code. For example, assault, threats, battery, destruction of property, and theft are all examples of intrafamily violence. The only requisite is that in order to be listed as an intrafamily violence offense, is that the alleged offender is related by blood, adoption, legal custody, marriage, or domestic partnership. The definition also includes situations where the offender and the victim have a child in common, as well as stalking. Victims of intrafamily violence can obtain civil protection orders. The law also places certain duties upon law enforcement investigating allegations of intrafamily violence. Are police officers required to arrest for an intrafamily offense in D.C.? A police officer is required by law to make an arrest whenever the police officer has probable cause to believe that a person committed an intrafamily offense that resulted in harm. It does not matter whether the offense was committed in the officer's presence. The officer will, or shall we say, is supposed to take detailed accounts of the victim's state of mind, appearance, etc. In general, when the police come to the house to deal with an intrafamily offense, someone will probably be arrested. Police officers also must make written reports of investigations of intrafamily offenses. The reports must be submitted to and maintained by the District of Columbia Metropolitan Police Force. What are protective orders? The District of Columbia law provides temporary and final protective orders to persons claiming to be victims of intrafamily violence. Having an attorney represent an individual for or against a protective order is crucial, as orders can contain a variety of provisions affecting the conduct of the parties. The disposition of property, the child custody, and visitation can all be handled by protective orders. A judge may issue a temporary protective order where the judge finds that the safety or welfare of the petitioner, that is, the person seeking protection, or a household member is in immediate danger by the respondent, the person for whom a petition seeks protection. The temporary protection order may be issued ex parte, that is, without the respondent's presence or input, but the order may not last longer than 14 days, except the court may extend temporary protective orders if necessary to conduct a hearing on the petition. After a temporary order is granted, the judge will conduct a full hearing where both the petitioner and respondent are present, and the judge will take testimony to decide whether the respondent committed or threatened to commit an intrafamily offense against the petitioner. The judge may issue a final protective order with any combination of the following provisions: prohibit the respondent from committing or threatening to commit crimes against the petitioner and other protected persons, prohibit the respondent from having any contact with the petitioner or other protected persons, require the respondent to participate in psychiatric or medical treatment or counseling, require the respondent to vacate or refrain from entering a dwelling, that is marital property or property that is owned, leased, or rented and occupied by both, or the judge can order anything the judge deems necessary to protect the petitioner from harm. The protection order will last 1 year unless modified by the court upon request of the parties. What happens if I violate a protective order? Any person who violates a temporary or final protective order will be charged with violation of a protection order or contempt and be fined up to $1,000 and sentenced up to 180 days in jail or both. Need more information? Call Rollins and Chan today at 202-455-5610.